The morning my stepfather filed to take control of my mother's estate, I was sitting in the parking lot of a Kroger in my beat-up Honda, eating a granola bar for dinner because I'd spent my last $20 on printer ink. I didn't know yet. I found out 3 days later when a certified letter showed up at my apartment, the kind with the green return card that you have to sign for. I almost didn't answer the door. I thought it was my landlord again. It wasn't. It was a notice from the Riverside County Probate Court. My stepfather. I'll call him my stepfather because that's what he legally was for 11 years, even though he never once acted like one. Had petitioned to be named sole executor of my mother's estate. My mother, Diane, had died 6 weeks earlier from a stroke. She was 58. She'd been healthy her whole life, or so we all thought. And then one Tuesday morning, she didn't show up to open her flower shop and her assistant found her on the floor behind the counter. I was the one who identified her body. My stepfather, Ray, couldn't make it to the hospital in time. He was in Vegas. He told me this over the phone with the TV on in the background. My mother had a will. I knew she had a will because she'd told me about it after Ray and she got married, when I was 22 and just starting my second year of college. She sat me down at the kitchen table and said, "I want you to know that no matter what happens, the shop is yours. Your grandmother left me that building and it belongs to our family." She'd squeezed my hand. I wrote it down. It's official. The flower shop wasn't just a business. My grandmother had bought that building in 1987 with money she'd saved for 20 years working as a seamstress. She'd raised my mother in the apartment above it. My mother had learned to walk between the buckets of carnations and the work table where my grandmother wired arrangements for weddings. I'd spent every summer of my childhood there, trimming stems, learning the names of flowers, doing my homework on the same work table with a glass of sweet tea. That building was worth $380,000 by the time my mother died. The business itself had accounts, inventory, a loyal customer base built over 30 years. There was also a savings account, $47,000 my mother had set aside specifically for me, noted in the will, intended to help me finish my degree and get started. Ray wanted all of it. He'd hired an attorney before my mother was even buried. I found this out later, but I want you to understand the timeline. My mother died on a Tuesday. The funeral was that Saturday. By the following Monday, Ray had already had a consultation with a probate lawyer. I didn't have a lawyer. I didn't have money for a lawyer. I was 28 years old, working as a bookkeeper for a small property management company, making $38,000 a year in a city where rent alone cost me $400 a month. I had $600 in savings. I had $19,000 in student loan debt. I had a mother who was dead and a stepfather I barely knew who was now trying to take the only thing she'd ever left me. Ray's argument, as laid out in the petition, was that my mother had lacked testamentary capacity when she wrote the will, meaning he was claiming she hadn't been of sound mind. He also claimed that I had exerted undue influence over her when the will was drafted. I was 22 when she wrote that will. I was in college 2 hours away. I saw my mother twice a month, if that. The petition was 43 pages long. I read all of it on my living room floor with a highlighter and a legal pad, cross-referencing terms I didn't recognize on my laptop. I'm a bookkeeper. I understand numbers, documentation, paper trails. I don't understand the law, or I didn't then, but I understand how to read carefully and I understand how records work. What I found in those 43 pages made my hands go cold. Ray had attached a letter, supposedly from my mother's doctor, stating that she had shown signs of cognitive decline in the 18 months before her death. I knew my mother's doctor. I'd taken her to appointments. I had never once heard anyone use the phrase cognitive decline in connection with my mother, who did the New York Times crossword puzzle every single morning and could remember every customer's name in their usual order going back 15 years. I also found a revised document. Not the original will, but something Ray's lawyer was calling a codicil, a later amendment. This codicil, supposedly signed by my mother 8 months before she died, removed my name from the estate entirely. I had never seen this document before. I stared at my mother's signature at the bottom. I had seen my mother's handwriting my entire life. Birthday cards, grocery lists, the little notes she tucked into my lunch bag when I was in middle school. Something was wrong. I couldn't explain it precisely, not yet, but something was wrong. I couldn't explain it precisely, not yet, but something was wrong. I called my grandmother's old friend, a woman named Beverly who had known our family for 40 years and who had worked at the flower shop part-time for the last decade. Beverly picked up on the second ring, and when I told her what was happening, she went silent for a long moment. Then she said, "Honey, your mama came to see me 2 months before she passed. She was worried about Ray. She told me she was going to call her lawyer and make sure everything was in order." "Did she?" I asked. "I don't know," Beverly said, "but I know she was scared." I started keeping a notebook. I wrote down everything, every date, every phone call, every document Ray's lawyer sent me. I wrote down what Beverly told me. I wrote down the names of every witness listed on the codicil. I wrote down the name of the notary. Then I started making calls. The notary, whose stamp appeared on the codicil, was a woman who worked out of a UPS store about 4 miles from Ray's office. I called the UPS store and asked if I could speak to her. The person who answered told me she hadn't worked there in over a year. I asked for her last name. They gave it to me. I found her on LinkedIn. She was now working at a title company in the next county over. I sent her a message explaining that I was trying to verify a notarization she had performed approximately 8 months ago related to a legal document. I included the date on the codicil. She responded within an hour. She said she had no record of notarizing any document on that date. She said she kept meticulous logs because her employer required it. She said if I could send her a copy of the stamp, she would check her seal number. I sent it. 2 days later, she sent me a message back. The seal number didn't match hers. I sat very still for a long time after I read that. Someone had forged the notary stamp. I went to work the next morning and I did my job and I did my job and I did not tell anyone what I had found. That night, I drove to the library because I didn't trust my home internet connection for some reason. I can't fully explain. Paranoia, maybe, or just the feeling that I needed to be careful. And I spent 4 hours reading about probate fraud, document forgery, and how to file a motion to contest a will in California. I also read about how to request a handwriting analysis. I had every birthday card my mother had ever sent me. I had a shoebox full of them going back to when I was 7 years old. I had her grocery lists. She'd texted me photos of when I was in college, asking me to pick things up on my way home. I had 30 years of her handwriting. I couldn't afford a forensic document examiner. The cheapest one I found charged $1,500 for a preliminary review. I had $600 in savings. I called Beverly again. I told her what I'd found about the notary. Beverly didn't say anything for a moment, and then she said, "I have some money set aside. How much do you need?" I told her I couldn't take her money. She said, "That shop was your grandmother's? It was your mother's. It is yours. Tell me how much." Beverly lent me $2,000. I cried in my car for 20 minutes before I called the forensic examiner. The examiner, a retired FBI document analyst named Mr. Kowalski, agreed to review the codicil against my sample documents within 10 days. He told me not to get my hopes up, that handwriting analysis wasn't always conclusive, that courts had become more skeptical of it in recent years. I told him I understood. I didn't tell him that at that point hope was the only thing I had. While I waited, Ray's lawyer sent me a settlement offer. It was 3 pages long and used a lot of impressive-sounding language, but what it came down to was this. I would receive $15,000 and a portion of the remaining inventory from the shop. Ray would receive the building, the business, the savings account, and all other assets. I would sign a statement agreeing not to contest the codicil or the appointment of Ray as executor. I would have 14 days to respond. I read it twice. Then I put it in my notebook, paper clipped it to the page, and wrote the date at the top. 14 days. I had 8 days left when Mr. Kowalski called me. He said he'd completed his preliminary review. He said that, in his professional opinion, the signature on the codicil was inconsistent with the authenticated samples I had provided, specifically in the formation of the capital D in my mother's first name, the loop pattern in the letter I, and the baseline pressure across multiple letters. He said he would put this in a written report. He said he would not testify in court for what I paid him, but he would provide the report and recommend me to a colleague who offered sliding scale fees for low-income clients. I sat in my car in the parking lot of my office building and I pressed my forehead against the steering wheel and I breathed. I didn't take the settlement. I filed my own counterpetition. I did it myself, using the California court's self-help website and 3 nights of barely sleeping. My nephew stood in my bain room and told me that my bain room, 67 years old. I'm Robert Sinclair. Robert 7 years old. I attached my mother's medical records, which I'd requested directly from her doctor under HIPAA, and which contained absolutely no mention of cognitive decline. Not once, not anywhere, not a single notation across 4 years of annual physicals and routine visits. The hearing was set for a Tuesday morning in October. Ray and his attorney were already seated when I walked in. Ray was in a charcoal suit. His lawyer was a tall man with silver hair and a briefcase that probably cost more than my monthly rent. They were talking quietly, and when Ray looked up and saw me come through the door alone, no attorney, no one with me, just me, in the navy blazer I'd bought at a consignment shop for $22, he smiled. Not a warm smile. The kind of smile someone makes when they think they've already won. I sat down at the table across from them, and I set my folder down, and I folded my hands on top of it, and I did not look at Ray again. The judge was a woman in her 60s with reading glasses on a beaded chain. She reviewed the docket and then looked up at both tables and said, "I've read the preliminary filings. Before we begin, I want to make sure I understand the respondent's position." She looked at me. "You're representing yourself?" "Yes, Your Honor." "You're aware that probate proceedings can be complex?" "Yes, Your Honor. I'm a bookkeeper. I work with financial records and documentation every day. I've done my best to prepare." She nodded once, and something in her expression shifted slightly. Not pity, something more like attention. Ray's attorney went first. He was smooth and practiced, walking the judge through the codicil, through the doctor's letter, through Ray's claim of my mother's declining mental state. He spoke for almost 20 minutes. He used words like clear and convincing and statutory requirements and testamentary intent. He was good. I'm not going to pretend he wasn't good. When it was my turn, I stood up and I picked up my folder and I said, "Your Honor, I'd like to start with the notary." I walked her through the stamp discrepancy. I handed her the message from the actual notary, printed and formatted with the date and header. I handed her Mr. Date Kowalski's report, flagging the specific pages where he described the signature inconsistencies. I handed her the notary's log records, which she had voluntarily provided and which showed no entry for the date on the codicil. The judge read. Ray's attorney objected twice. The judge overruled both times and kept reading. Then I handed her my mother's medical records. All of them. 4 years of appointments. I'd made a 1-page summary on the front dates, attending physician, notes, diagnoses, and the word cognitive appeared exactly 0 times. The petition claims my mother showed signs of cognitive decline, I said. Her own physician's records don't support that. I'd like to know who produced the letter claiming otherwise, and whether the court can verify its origin, because it doesn't appear in the records I received directly from her doctor's office. Ray's attorney stood up. Objection, Your Honor. The respondent is making allegations without— Sit down, the judge said, not loudly, but clearly. She looked at Ray's attorney. The letter attached to your client's petition. Do you have documentation of its provenance? Who generated this letter, when, and under whose signature? There was a pause. We can provide that, Your Honor. We'd need a brief continuance to— You filed this petition 11 weeks ago, the judge said. You had 11 weeks. The silver-haired attorney sat back down. I kept going. I had the settlement offer Ray's team had sent me. I showed the judge the timeline, 14 days to respond, the pressure built in. I showed her Beverly's statement about my mother's concerns in the weeks before her death. I showed her the original will, notarized in 2019 by an attorney whose license I had verified through the California State Bar website, whose contact information I had included and who had confirmed in an email, which I also printed, that he had met with my mother alone, that she had been of clear and sound mind, and that she had expressed her wishes without any outside pressure. I don't know how long I spoke. It felt like a long time. My voice stayed steady. When I sat down, my hands were trembling slightly under the table where no one could see them. The judge asked Ray's attorneys several more questions. He answered some of them and deflected others. At one point, the judge asked him directly whether his client had been present in the state on the date the codicil was supposedly signed, and the attorney said he would need to verify that. The judge removed her reading glasses and set them on the bench. "I'm going to be direct," she said. "The evidence presented today raises serious questions about the authenticity of the document your client is relying on. I am not prepared to rule on the merits of this petition without a full evidentiary hearing, and I am referring the matter of the notary stamp discrepancy to the district attorney's office for review." Ray made a sound, something between a cough and a word. His attorney put a hand on his arm. The judge continued, "In the interim, I am issuing an order freezing all estate assets pending the outcome of this hearing and the DA review. The flower shop and associated accounts will remain under court supervision. A full hearing is scheduled for," she looked at her calendar, "February 18th. Both parties are required to appear with full documentation." She looked at me over the top of her glasses. "You did your homework," she said. That was it. That was all she said. But I had to press my lips together hard to keep from falling apart right there at that table. Ray didn't look at me as we left the courtroom. His attorney walked very quickly. I stood in the hallway for a moment, just breathing, and then I went to the bathroom and I sat on the closed lid of a toilet stall and I let myself cry for exactly 5 minutes. Not sad crying. The other kind. The kind where something that has been coiled tight inside you for months finally loosens. The full hearing was in February. Ray's attorney withdrew from the case 2 weeks before it, citing irreconcilable differences with the client. A new attorney filed a notice of appearance, but by then, the DA's office had already begun a formal inquiry into the forged notary stamp. At the February hearing, the judge ruled the codicil was invalidated. The original will, my mother's real will, the one she'd written sitting at her kitchen table and signed in front of her own attorney, was reinstated. The estate passed as she had intended. The flower shop was mine. The savings account was mine. Ray was not criminally charged, ultimately. His attorney argued, successfully, that there was insufficient evidence to prove Ray himself had known the stamp was forged, that it could have been the work of a third party. I don't know if I believe that. I don't think I'll ever know for certain. But the DA did issue a referral for further investigation, and 2 months after the hearing, Ray quietly moved out of the state. I went to the flower shop on a Thursday in March, the week after the estate officially transferred. Beverly met me there. She had a key. She'd kept one all along, had been going in to water the plants and keep the space from dying while everything was frozen in legal limbo. We stood in the doorway for a moment. It smelled like it always had. Cool and green and a little bit sweet. The same brass bell above the door that my grandmother had hung in 1987. I paid Beverly back every dollar she lent me. She cried. I cried. We split a bottle of wine at the work table where 3 generations of women in my family had done their work. I still run the shop. I hired a part-time assistant, a college student who reminds me a little of myself at that age. Serious eyes, works hard, doesn't say much until she has something worth saying. I started taking a bookkeeping client or 2 on the side while I got the business back on its feet. It's not easy. I'm Robert saying it is. Some months are tight. I still have the student loans. The building needs a new HVAC unit that I'm slowly saving toward, but every morning I unlock the brass bell door and I turn on the lights over the work table and I set up the buckets the way my grandmother taught my mother and my mother taught me. And I think about how close it came to being gone, how close Ray came to walking away with all of it. How I almost signed that settlement offer at 3 in the morning because I was tired and scared and I couldn't see a way forward. I didn't sign it. I kept my records. I followed the paper trail. My mother taught me that. She taught me that everything important leaves a mark if you know where to look. I know where to look. I've thought a lot about what Ray must have been counting on. He was counting on me being broke. He was counting on me being grieving and exhausted and too overwhelmed to read 43 pages of legal language carefully. He was counting on the fact that I didn't have a lawyer, that I'd look at that settlement offer, $15,000 and some leftover flour inventory, and think, well, it's something. He was counting on me folding. And I almost did. I want to be honest about that. There was a night, maybe 2 weeks after I got that settlement offer, when I sat at my kitchen table at 2 in the morning and I genuinely considered signing it. Not because I thought it was fair, not because I believed for 1 second that my mother would have wanted Ray to have her shop, but because I was tired in a way I hadn't ever been before, and fighting felt like something that happened to people with more resources than me. What stopped me wasn't courage exactly, it was the notebook. I'd been writing everything down for weeks by then. Every date, every document, every discrepancy, and I looked at those pages and I thought, the answer is already in here. You just have to follow it. That's not bravery. That's just not quitting before you've finished reading. People talk about intelligence like it's something you either have or you don't. I don't think that's right. What I had wasn't brilliance. I'm a bookkeeper. I balance accounts. What I had was the habit of paying attention. My mother taught me that. Beverly, who lent me money she didn't have to lend because she believed in what was right, reinforced it. Mr. Kowalski, who answered a message from a stranger and told me the truth about that signature, showed me what it looks like when a person takes their work seriously enough to follow the facts wherever they lead. Ray made choices. So did everyone else in this story. Beverly chose to pick up the phone and then write a check. Mr. Kowalski chose to be thorough. The real notary chose to check her records and tell the truth, even though it put her in an uncomfortable position. I chose not to sign the settlement. All of those choices stacked up into a particular outcome, not because the universe was keeping score, but because actions have weight. What you do and what you refuse to do accumulates. That's the thing I keep coming back to. Ray didn't lose because he was punished. He lost because the evidence he built his case on couldn't hold up to someone who looked at it carefully enough. Dishonesty tends to work only as long as no one checks. The moment someone starts checking, it starts to fall apart. That's not fate. That's just how paper trails work. My grandmother bought that building with 20 years of careful, honest labor. My mother kept it with 30 years of showing up and doing good work and knowing every customer's name. I kept it with the notebook and the library computer and the refusal to stop reading until I understood what I was looking at. I think about that on the mornings when it's hard, when the HVAC rattles and the margins are tight and I'm tired. I think about what it took to still be standing in that building, and then I turn on the lights over the work table and I start.